Good afternoon, everyone, and welcome. Today's topic is privacy in the 21st century, past, present, and future. And we're going to take stock of where privacy law was and where it is and where it's heading. I have a great group of panelists with me. I've got Margot Kaminski from Colorado Law School, Ari Waldman from UC Irvine, and Salomé Viljoen from the University of Michigan Law School. So thank you so much for joining me. I'd like to begin with what inspired this topic, which is that I just completed an update to my casebook, and the new book just came out. I'm really excited about it. It's the 8th edition. That means I've been doing a lot of updating, and every time I do a new edition, I think it's unfair that other casebook authors in other fields just basically get to change a sentence. Maybe they'll change a note or one case where I have to write the whole book again, practically. Paul Schwartz and I. And I should mention that Paul Schwartz is unable to join us today. Something came up at the last minute. He was scheduled to join us, but unfortunately he cannot. But he still wanted things to go forward and sends his best regards. So I will, cover our team. Paul Schwartz is my co-author on this book. I will want to note just something really interesting about the book is that initially in the early days, and this is the book was first published in 2003, it was a hard sell to get the publisher to publish a casebook in privacy. A lot of work went into convincing them that there was a field here, that there was privacy law, enough privacy law to warrant a book. And in fact, they didn't even give me a traditional casebook. They published it as a softcover book and said, look, we'll just do it as an elective series softcover because, we don't think there's enough here for, a full course. So I kind of got this series here as a paperback. What's nice is after that, they did see that there was a field, and it now is in its 8th edition, and it has a hardcover, just like the other casebook. So privacy law, I guess, has finally arrived. It's no longer just a satellite type of thing on the periphery. So I think that's been a major change in the law, is that, I think that today we certainly recognize that there really is a field here. There are many privacy lawyers. At the time that, I came out with the book in the beginning of the century, there were hardly any privacy lawyers. I could count maybe, 10 of them, if that, that were practicing in companies or at law firms. There were just a handful. And there were a few professors that were working on this, but not many. Now there's quite a lot. So the number of people involved in the field and the number of laws has increased rather dramatically. But I'll stop there, and I wanted to get some of your thoughts on the development of privacy law. And I'd like to start by, I guess, looking at the past and how would you characterize how we got to now? How would you describe the evolution of privacy law from its early days to the present? And I thought I'd start with Ari. You have some, you've actually written a book recently about privacy law, a really great book that I'm going to assign in one of my classes. And I have it here too. Voila. This is a great book. It's really succinct, and it walks through the development of privacy law. So if someone wants a really succinct guide to privacy law, this is it. I mean, and it's a lot cheaper and easier to read than my casebook. They're all here, and you have a lot of perspectives. And what's interesting here is it's not just telling a kind of story, but you have an opinion about this, and you express that, and here you take a viewpoint about the development, is it good or bad, and what were missed opportunities in the development of the law. But anyway, I'll let you talk.
Yeah, thank you, Dan. Thanks for including me in this. It's great to be here with you, Margot, and Salomé, of course. And also thanks for essentially being my agent. I'll have to hire you for that as well. So one of the things that I talk about in the little booklet, and I've talked about before, is that I think where we are right now, and one of the best ways of understanding how we got here is to think about evolutions in privacy law as a series of waves, borrowing this language from, of course, the development of feminist theory and approaches to feminism. Our first wave, which can be characterized by privacy policies, click to agree buttons, the FTC originally not wanting to be involved in regulating anything having to do with privacy, but then becoming essentially enforcers of companies' privacy policies. This was reflective of a laissez-faire moment or a deregulatory moment when the internet became generally popular. The government was much more hands-off, reflecting on the desire to not get government involved for fear of stifling innovation. We can talk about whether that's real fear or not a real fear. But that's why, given that moment, given the historical contingencies of when the internet became more popular and privacy concerns became more popular, they came about at a time of anti-regulation, of deregulation. So we got a lot of, we're not going to do anything. Let's just allow companies to put up privacy policies. They can decide what's in it, and then you can just agree or not agree. And that evolved to the point where we started to have some laws still in this very first wave of notice and consent or notice and choice, where the law stated, well, you have to have certain things in a privacy policy, but what's going to happen with your data, with people's data, what are the uses of it, and so forth. But that was it. And then we've moved into what we'll call the second wave of privacy law that's focused more on maybe reflective of our neoliberal moment, a neoliberal moment that sees the individual and general welfare as very connected, and also invites partnerships or sees governance as a partnership between industry or organizations and the government. So that's why we get these two sides of the coin of laws like the GDPR and two sides of the coin of proposed laws like the American Data Privacy and Protection Act, which failed in Congress last year. These have a combination of individual rights of control, like rights to delete, rights to correct, right to opt out, to port your data from one company to the next, and combine it with compliance obligations, mostly procedural compliance obligations. These are impact assessments, record keeping, and so forth, right? And hiring privacy offices. And these are not all so new. I mean, privacy rights are as old as the Q report from the 1970s. And impact assessments and hiring privacy offices have been around in Europe for quite some time. And the FTC required it as recently as early as 2011 in a Google consent decree. And companies were doing that even a little bit before. So the laws of the second wave very much reflect kind of a ground up evolution of law. And that's sort of a descriptive argument, I think, about how I think about where we've gone. The more normative argument is I think all of this is pretty bad. And in some ways, the second wave may be a little bit worse than the first, even though it seems like there's more governance there and everyone calls the GDPR and other laws in their vein stricter, and that it's better to have more rights than less rights. I get all of that. But what these laws do, in addition to the compliance work being very subject to capture, and I wrote a whole other book about that, this idea of combining rights and compliance provides some legitimacy to the data extractive practices that those forms of governance leave untouched, right? So the second wave is not geared toward changing in any material way the data extractive economy. It's just meant to provide kind of guardrails around it and give some tools of control as advocates use all the time, and perhaps some accountability. But everything else, the underlying injustices, manipulation, and so forth of the economy are left intact. And as a result, now that we have all these tools that companies have to engage in and people have to supposedly control where their data goes, it seems more legitimate, right? And that's a general problem with throwing procedural rules and rights-based rules at underlying structural problems.
So I'd like to, I think, turn to Margot next. I presume you have a little bit of a cheerier perspective on privacy law, though that's not hard.
Yeah, I think there's more, as Ari and I find every time we disagree, there's more common ground there than might be apparent. But I'm going to actually rewind the history a little bit and tell a slightly different story, which comes in part from the fact that my work is comparativist. So I look also at what's going on in the European Union, kind of in parallel to what happened in the United States. So even before the laissez-faire moment that I completely think Ari accurately described in the roughly 1990s, where Congress decided not to pass a number of big privacy laws, the US had privacy torts and had the Prosser privacy torts, which were enacted or recognized state by state. And the difference between those torts and the data privacy that Ari talks about in his book and is the subject of most, but not all, of your book with Paul, is that those torts look like media torts. So they're really about the collection and dissemination of information through sort of old school news media. And we can talk later about how those are similar or different from data privacy, but noting those existed. And then you have the Hugh report, as Ari correctly notes, again in the, I think it was the early 1970s. And in parallel to that, efforts in the UK to establish a series of principles for governing data privacy, which is really what we're talking about, is when individuals often consensually hand over their personal information to some big impersonal organization, and the FIPS, or the Fair Information Practice Principles, attempt to establish a series of individual rights, Ari also referenced, to recalibrate the power imbalance that happens when you're handing your information off to an entity that you can't socially check because they're impersonal, they're bigger, they're more powerful, et cetera. So the FIPS get established, and the US does roughly nothing with them except through these sectoral laws, while in Europe, you see member state after member state enacting data protection laws, which were on the books quite early. And they were first consolidated EU-wide into a sort of light touch requirement under the Data Protection Directive, and then hardened in law, in a legal sense, into strict requirements, direct requirements on EU member states with the infamous GDPR, which came into effect in 2018. And so when you look at that story comparatively, yeah, the US went a laissez-faire light touch route, relying predominantly on disclosure or notice and choice. I think missing from Ari's story a little bit is the policy entrepreneurship of the Federal Trade Commission, which stepped into that vacuum, as Chris Hoofnagel and others have written about, and started doing some significant consumer protection related enforcement there. And then you get largely stagnation in the US until roughly when the GDPR comes into effect, when California passes the first omnibus data privacy law in the United States with the CCPA, followed closely by a number of other states, including my own home state of Colorado, and followed by a significant amendment to the California law, the California Privacy Rights Act, which goes back through the CCPA and I think makes it considerably stronger and potentially more effective. So my optimism comes not so much from disagreements with Ari about the potential for whitewashing or policy washing or capture, but from the fact that I think that both in Europe and in the United States, there's significant, I want to wait and see. There's significant opportunity for enforcement agencies to come in with real sticks that didn't exist pre-2018. There's opportunity for the state AGs, which have only just started enacting rules that really recently went into effect, to start enforcing those rules. And the California Privacy Protection Agency is the first privacy specialist agency, to my knowledge, in a US state, and wields both enforcement power and significant technological expertise. And their rules just came into effect in March. And then they have another set of rules that are going to be probably promulgated in the coming year. So my optimism is let's wait and see. There's opportunity for capture, but there's also significant opportunity for real interesting evolving enforcement. And I have more faith in the backbone of the combination of FIPS with risk assessments and other corporate governance requirements, I think, than Ari does.
So Salomé, I'm curious where you weigh in on all this. Are you a glass half empty, a glass half full, or somewhere in the middle?
Yeah, thank you. And thank you so much for having me here. It's a pleasure to be able to join you all in this conversation. Yeah, I think I'm sort of like a Goldilocks third, putting myself a little in the middle of Ari and Margot here. So similar to Margot, completely agree with Ari on the characterization of kind of the history of sort of the two waves of privacy. I really like Ari's language of waves, of thinking about them. Similar to Margot, I do think there's some grounds for potential optimism around how inventive and entrepreneurial, for lack of a better word, regulators kind of take these relatively new laws that we have in the CCPA with the PRA amendment and the GDPR and see if they can push kind of what I would like to see, just fairly ambitious theories of enforcement of some of these relatively new forms of privacy enforcement. So I sort of share Margot's sense of let's wait and see, particularly when it does come to kind of core privacy interests and core privacy rights that these laws are trying to kind of vindicate and empower a bit more. Where I would sort of temper, and it's not like Margot was overly rosily optimistic, it was sort of a let's wait and see view. What I will say is that I think while these laws, I think in part reflect people being policymakers, legal scholars, and civil society groups getting savvy about the kinds of privacy interests and the kinds of privacy rights that we have to demand from these new laws. And as there's increased social literacy around important privacy, I think we've just gotten smarter in knowing what we need to ask for and pushing for those things in these laws. And I'm sort of optimistic about that. For example, I think the conversation about rights, private rights of action, I've sort of noted a positive shift, I think, in sort of the background in terms of what private rights of action can and can't do and the role that they can serve in these kinds of laws. I do still think that there are just sort of big conceptual gaps in the approach that these kinds of privacy laws can take. That isn't really pessimism about what they can do. I just think that they can sort of vindicate a certain set of informational interests and informational rights that are very important for the 21st century, but that they might not be able to do everything that we want to do when it comes to kind of constraining power in the information economy or protecting people as they kind of enter various kind of digital marketplaces. So yeah, maybe it puts me in the middle of Margot and Ari. Maybe that puts me in the category of like some secret third thing. But that's sort of where I would place sort of optimism about where privacy law is going.
Yeah, and I would put myself kind of somewhere in the middle because I agree with most of Ari's. I agree with all of you actually. So you're all right, and I think that it's heartening to see how much law has been passed and how much has changed from the earlier days. Quite a lot has happened. It's great to see the states in the U.S. start passing privacy laws. It's disappointing that they chose an approach that was really focused so much on individual control or privacy self-management, still based on notice and choice, which has been critiqued for really since scholars started writing about this. And I think that's really unfortunate. That they have taken that approach when it was largely discredited for a very long time. The GDPR is certainly a big advancement. I think it's a great law, but I think it's still an early law. I think we're still struggling to figure out how to regulate this. The GDPR does a lot of good things, but there's also a lot of things that I agree with Ari can be hollow in the way they're done. Not that they're bad things. I think having a privacy officer, a privacy program is good. I think doing assessments is good. I think privacy by design is good. The question is the rigor of how that's done and the level of accountability. But I also take to heart, a point that Ari has made here briefly, but also, a lot more, in depth elsewhere, which is we are still, if you look at the bigger picture, we zoom out, we have a lot of law, but, I don't think many would say, problem solved. We're happy at the state of privacy here today. The fact is that, the companies do wield tremendous power. They do collect and use data in, an incredibly vast amount of ways. And people are at risk and are harmed by this. So we do have the law, but in essence, if we look at what's going on, it does seem that the practices of data collection and use are essentially not fully under control. They are still growing and increasing, and the problems are still very much there. So the law does have some work to do, even if it's doing all these things, because the world of data collection and use is keeps on trucking, and actually not just trucking, but it gets stronger and stronger and stronger. We need the bigger picture. There are some massive problems that the law still has to address. Go ahead.
Yeah, just to add on that, I think I just wanted to reflect on Margot's intervention about adding in a little bit more of the history, which I think was a really important intervention, because I think we all, as Margot said, there is always more agreement when we get together to talk about this. But where our differences may lie is, what do we do next, right? So the beauty or the importance of Margot's intervention in the history reminds us that there are other models, not to suggest that the laws that the United States passed in the 70s weren't very much notice and choice in the sectoral model, in the sectoral approach, but it's not like this is always brand new turf. Certainly new technologies happen, but we're capable of doing things, and or at least we used to be capable of doing things. And my optimism includes us being capable of doing things again. And then it's just a matter of, okay, well, what we have to decide as a society and as scholars, like, what should be the goal of privacy law? If the goal of privacy law is to do what the GDPR does, right? Then I think, well, maybe we don't progress far much from the second wave. But one of the beauty of the waves analogy is that waves, the many different waves that we've seen in feminist scholarship and feminist activism are very different, right? They came from an assessment as groups of advocates, activists, and scholars were achieving change in some way, of seeing, well, what is missing from the change that we are accomplishing now, and what do we do then? So yeah, we're all waiting and seeing, but we're not just waiting. And I didn't think this is what everyone meant. I mean, we're not just waiting. We are conceptualizing what we think the next stage of activism and advocacy has to be. And is it tearing down the information economy and building something up? I mean, sure, that would be wonderful, but I don't think we can do that tomorrow. But on the other hand, what kind of changes do we think we need? And I think that's where all of our work is headed. I think that's so important to have comparativists like Margot, and so important to have theorists like Salomé doing this work, because we can see, we can think about these differences, these different conceptualizations and different models, and see where we want to go next. And that's really what's going to determine what the third wave is going to look like.
I just want to pop in because I noticed a question in the comments about what is the crux of the critique of notice and choice, And for those of you not familiar with some of the scholarship and critiques of notice and choice, essentially the notice and choice approach is that companies would provide in their notice what they're going to do with the data. This is the data we collect, and this is what we do. And then the onus then becomes on individuals to either opt out or to not do business with the company. But essentially, the company can do what it wants with the information as long as it provides notice of that. And this approach is critiqued because there's a lot of ways that companies can get individuals to allow the use of their data without really understanding the risks to them. Most people don't read privacy notices. Fewer than 1% do, so they don't really get informed. Even if they could read if they had time and read the notices, it's not clear they'd really understand them. And the notices are also written in ways that don't really fully disclose what's going on with the data, and they can be unilaterally changed by organizations at any time. And this approach generally becomes a fairly self-regulatory approach and very permissive, where companies can do what they want. And the GDPR does try to take a different approach, where it has lawful bases to process data. But those too can be pretty permissive. Consent can be readily obtained. And the legitimate purposes justification is pretty broad too, that allows companies to use data for a wide array of purposes. It's more limited than in the US, but still it's a pretty permissive regime where there's a lot of data use allowed, with individuals not really knowing and not really being able to make good risk calculations about, is this use going to create a problem for me or harm me?
I have thoughts.
Go ahead. Yeah.
So I'd say that in a nutshell, it's important to distinguish between notice and choice and individual rights, because notice and consent, notice and choice is really a US thing. And as Dan has outlined really well, the problems with notice and choice as it was operationalized in the United States, which is that you don't really get effective notice and you don't really have a choice. When you get to the individual rights, which are more, the FIPS-based individual rights of access and correction, and even deletion in some contexts, that's the backbone of the individual rights portion of the General Data Protection Regulation. Those look different in practice potentially, because the GDPR and these new state data privacy laws do put in requirements that those have to actually be effective. Like, people need to be able to access those rights and use them. But then the question that we're left with there is, again, to Dan's point, who actually has the time and energy to go and operationalize these rights? And if individuals don't have the ability, time, and energy to do it, then they're basically dead letter rights. And if you don't have a top-down regulator saying this is what you can and cannot do with data, then in the default of people not using their rights, then companies will do anything they can with personal data. So that, I think, is the gist of the problem. The only, again, sunny optimistic addition I will give to that, from my take, is that in the absence of a significant number of transparency mechanisms on the systemic level, individual rights a la the FIPS are some of the only pieces of insight that we get into what's actually going on in companies. So maybe, I'm sorry to punt us forward into the future conversation, but maybe one thing to think about when we start talking about a third wave or a different model might be, how can you get the accountability and transparency that individual rights are currently being asked to perform, without relying so heavily on individual rights, because right now we don't have it.
So I wanted to actually shift to the future and start talking about with you, Salomé, about any thoughts you have on the notice and choice conversation, as well as the future. And in particular, I want to throw out that in a really interesting paper, Maria Angel argues that there's been an algorithmic turn in the scholarship, and I think we're even seeing that, perhaps maybe in policy as well, where a focus on the complex algorithms that are being used to in AI, for example, are now changing the debate, changing the discussion. And perhaps even changing the way that policymakers are legislating. And we see just very recently, just the other day, the EU has reached an agreement on the AI Act. So I'm curious your thoughts on the future and this the algorithmic turn, and is this showing that there might be a real change in the way that privacy might be regulated, or how we might think about privacy?
Yeah. So I think it's a nice follow-on question from some of the themes that Margot was touching on about kind of the relationship between notice and choice, or notice and consent models, and these like ancillary individual rights that we have. Because in some sense, I think the way that I sort of could conceive of or think of the algorithmic turn is not as this like brand new problem or a sort of brand new application of information, but really a heightening of trends and of tensions that have been there for a very long time. And I think that as information gets used far more in these algorithmic products, and the most one of these generative AI products, I think some truths that have been maybe a little bit more buried are coming to light, and a lot more are seeing them as not just sort of follow on or downstream from things like individual data collection and privacy harm, but really kind of core to the entire project of why companies and governments are interested in collecting information about people to begin with. And so maybe I'll use that as a sort of way to say, kind of another critique that I really have of notice and choice models is not just that they, as Margot very succinctly and correctly put it, don't actually give you notice and don't actually give you choice, but as the legal conceptual matter kind of miss a lot of what's happening, especially with the algorithmic turn, with people's information, which is that when a lot of entities are collecting all of the Salomé information that they're sort of gathering about me, they're not sticking it in like a Salomé folder to know about me as an individual. They're using that information to train a lot of models, to create population level predictions, to create like sort of classifications based on groups, to then kind of inform a bunch of business strategies, some of which will be about me individually, and some of which will be sort of general prescriptions about people that share relevant features with me. And the reason I say all of that is to say, in law, notice and choice are sort of classic contract rights. So if something is going to be affecting me, then I can contract with it. I can sort of be awarded notice and exercise choice about things that affect me. But in the information economy, and especially I think with the algorithmic turn, it becomes very clear that that's just the wrong category of legal interest to even be working with. Because if information about me is fundamentally always kind of affecting of other people, and if a lot of decisions that can affect me are derived from information that I didn't individually turn over, then that's just like not actually providing notice and not actually giving choice, like failing kind of in the operationalization of the legal concept. It's the wrong legal concept to even be applying. And I think if there's benefit in the algorithmic turn, it's sort of heightening that insight that I think was there before, but becomes much clearer when you think about the application of information and training things like algorithmic models. So where does that leave us? I think coming back to sort of Margot's point about the GDPR, you have certain data protection frameworks and privacy frameworks that try to say, okay, well, we should supplement notice and choice, or we should give other bases for legitimate processing, as we have in the GDPR, that grant people ancillary rights, right? And those can do some work. They can secure certain interests, I think, under the algorithm turn. But what I'm, certainly far more interested in, and which Margot's answer kind of hinted at, is given this kind of non-individual, non-contractual sort of legal category of action that's happening here, how can we start to think about more kind of structural responses that maybe are empowering certain oversight agencies that don't require the operationalization of just individuals kind of eking back certain kinds of rights and obligations on their own. And I think that's the kind of work that all of us are really interested in. And I see the algorithmic turn as kind of just heightening the importance for policymakers and kind of the lay public, I think, of some of those themes that, I think in the privacy scholarly community certainly have been there for some
time. Ari, what are your thoughts on all this, in particular the algorithmic turn, and where you see the law heading in the future?
So I think that I agree pretty much with what Margot and Salomé have been saying, but I'll only add that there have been, this isn't the first quote unquote turn in privacy scholarship or focus of policymakers. I think what algorithms, machine learning, whatever term, artificial intelligence, whatever term we want to use for it, I think what the technology does is highlight or even metastasize some of the old problems that we have been talking about and scholars like you, Dan, have been writing about for decades. And that what matters is that all these problems are related, right? And this is an argument that civil society offered during the ADPA, the American Data Privacy and Protection Act negotiations, was that, well, we can't do anything about AI until we do something about privacy. And the way to do something about AI, and then I mean, that makes sense. And then, of course, the real issue is what they say next, right? Well, the way to do something about privacy is rights, or the way we do something about privacy is impact assessments, or the way we do something about privacy is data minimization, and its enforceability problems, and so on and so forth. So while we need conceptions of law and technology, the relationship between technology and society, and we need to understand these effects in far more detail than we do now, a lot of this stuff isn't that new, right? Everyone thinks, so you just open the newspaper for a couple months and ChatGPT and AI and chatbots, this is the biggest change that is ever going to happen in the history of everything. And then you just look at science technology scholars and say, I've heard that before. They said that about the telephone. They said that about the printing press. They said that about cars. They said that about this. That what happens is the technologies take on the structures and the influences and the systems that are in place in society at the time. Their regulation reflects cultural, economic, and political winds of the moment, and we're going to adapt to them. To the extent that privacy scholarship has taken on an algorithmic turn is really a reflection on the fact that privacy scholars are reflecting on on a technology that raises privacy concerns. So I don't see it as radically different than the kinds of things that we've been thinking about before, in that we still have the same basic concerns about privacy. What it may do is, and I think a lot of us are hoping for this, the more accessible or the more devastating or the more obvious privacy problems come to non-experts, the more it might be possible to have a social movement, an active social movement around privacy that will make it possible for leaders, policymakers, whether we're talking about the local, state, or federal level, to actually pass an effective privacy law that does protect consumers. And importantly, not just protect consumers, because consumers are going to be fine, but we also have to think about privacy laws protecting minoritized populations that are often the ones that bear the brunt of manipulation and harassment and the harm caused by a data extractive economy. And hopefully that's what the third wave does. And the harms and biases of predictive algorithmic, and other forms of algorithmic technologies highlight that.
Margot, what are your thoughts?
So many. So I want to highlight what I think is the real important contribution that Salomé and also Dan, your colleague, Alicia Sala-Niederman, have made, which is to remind privacy scholars and policymakers that my individual choices impact your opportunities, right? It's this idea that if all we have in privacy law is a series of individual rights, it might help me exercise my autonomy and rebalance the power imbalances between me and said impersonal company. But it's not going to get to system level and even population level harms, including, as Ari noted, harms to minoritized populations. So I think what I want to outline this is not so much my what do I think the future should be as what is the near future post-algorithmic turn. And I think that what's happening is that when you look at laws that are characterized as algorithmic accountability laws as opposed to data privacy laws, and there's lots of overlap between those two. GDPR has an algorithmic accountability provision in Article 22. The CIPRA, the California Privacy Rights Act, has an algorithmic accountability provision. So lots of nesting there. But if we look at things that are algorithmic accountability rather than data privacy, you see, one, the offering of a much more robust individual right sometimes at the use stage of data. So when companies are using AI or other kinds of algorithms to make a significant decision about a person, the GDPR offers a right to challenge that decision or to contest that decision. And California is now adopting new regs that offer rights to opt out of being subject to said decisions that are very similar. And then you see on the other prong, a shift to focus on these population level harms, including bans on discrimination, but disagreement about what it means to discriminate. And the use of tools, regulatory tools that Ari really doesn't like, such as the impact assessment or risk assessment, which really task individual companies or government agencies, depending on what the law is, with running an assessment of system level, population level, demographic level risks before and during deployment of these algorithms. So these look at first glance a lot like the individual rights and risk assessment, collaborative governance approach. But I think that both of them have more oomph behind them. And that's my portrayal of the near future differences between those two fields.
So I'll weigh in a little bit on this and then ask a question that I'd love to get your thoughts on the First Amendment, how this impacts all this. And on the algorithmic turn, I think that there's certainly a change in rhetoric. People are using the term AI a lot more, using the term algorithms a lot more, which really weren't used that much in the earlier days of privacy. I wrote an article struggling to sort of capture a lot of the phenomena that are going on, which is making inferences through the analysis of a lot of data. And there wasn't a term. There wasn't really anything to use to talk about it, even though the term AI was around since it was coined in 1955. It was really reserved for sentient robots in sci-fi. But there was a kind of rebrand that happened in the last 5 or so years where certain types of algorithms, machine learning and deep learning algorithms, got rebranded as AI. It's not really clear they are AI, at least in the sense that we're not seeing like actual thinking robots. They're just algorithms that try to simulate how what the next word is that gets predicted in a text bot, and so on. So they're sophisticated algorithms that are fueled by a lot of data. But this problem has existed since the earlier days of privacy. There was a lot of data. There's more now. So it's like it's on steroids. And we're struggling for a term. I used the term computer databases. I talked about the aggregation effect. Then after September 11th attacks, and when it came to government data gathering and pattern analysis, the term data mining was used. And then the term big data became into vogue. Then people started talking about algorithms. probably around a decade ago, inferences, algorithms, and now, throw the term AI on it to make it sound even more sexy. So that's been the progression, but the problem's been with us, and privacy law has been trying to deal with this for a while. But we do see, I think, the use of these terms a lot more, and a recognition about some of the things that you've been mentioning, that this involves decisions about you could involve data about a lot of other people. And that their decisions and what they do could affect how these algorithms are producing outputs that are used in decisions affecting your life, and that creates all sorts of problems with bias in the data, a whole host of problems. And I think the new breed of regulation that we're seeing, the regulation with AI in its title, like the EU AI Act, does take a different approach. It's a risk-based approach. It doesn't have much of anything about individual rights in it. It focuses on harm and risk and addressing that. So it breaks away from this individual control model. However, we are seeing in the United States some headwinds on privacy regulation, in particular, a lot of First Amendment challenges to this regulation. And I wanted to get your thoughts on what you think the impact of the First Amendment might be on privacy regulation, especially if we move away from notice and choice and the individual rights approach to a more regulatory approach that involves risk. How is this going to square with the First Amendment, and what are your thoughts on generally how the First Amendment should operate, how it might operate, and how it should operate with regard to privacy laws? And Margot?
I'll take a swing at that. It's not good. We have a Supreme Court that is increasingly lending a friendly ear to First Amendment challenges, freedom of expression challenges, to all kinds of regulation, definitely not limited to data privacy laws. But the path that they have laid out includes much increased opportunities to challenge laws as compelling speech. So any law that relies on disclosure, including, by the way, a classic notice and choice model, potentially gets challenged under the First Amendment for compelling speech. They've laid out in a separate doctrine about content-based or speaker-based regulations the idea that a narrowly targeted law, which, in the United States, our laws tend to be less omnibus, and we try to go after, for better or for worse, specific types of entities that are producing specifically egregious harms. But that potentially opens laws up to challenges for targeting only specific speakers, because the more broad your understanding of what a speaker is, the more likely it is that a distinction between a business of one size and a business of another size might be a distinction between speakers, and therefore unconstitutional. And then the last thing that I'll say is that the court is really moving away from, in a series of cases that might look like they have nothing to do with data privacy law, moving away from tiers of constitutional scrutiny that allow for a real consideration of countervailing government interests to an increasingly categorical approach, which basically says, if speech, then unconstitutional, without even looking to see what the government interests might be. And often they're government interests in the interests of many individuals on the other side. So none of those things are good for data privacy law or many other forms of regulation. And I'll just point everybody to a recent decision in the Northern District of California about the California Age-Appropriate Design Code Act, Children's Age-Appropriate Design Code Act in California, where I think a very misguided district court judge took every single one of those potential challenges to its illogical and deregulatory conclusion, and produced the worst case roadmap for data privacy laws. Now, in conclusion, I think I am more optimistic that other judges, including the Ninth Circuit, won't go that route. There's plenty of opportunity within the court's current jurisprudence to especially with the upcoming other net choice case at the Supreme Court about content moderation and regulation, that the court will hopefully recognize the significant regulatory interests when we have monopolies of power by these large communications platforms and other kinds of entities such as data brokers, and that the worst case scenario won't come to pass. But I'm cautiously optimistic.
So, Salomé or Ari, do you have thoughts on the First Amendment? Does anyone else want to weigh in on this? Ari?
Sure, very briefly. Margot was 100% right, and I'm cautiously optimistic too about this. But it also shows the First Amendment aspect here is one way that we can see the intimate connections between what seem like just general concerns about consumer privacy and the rights of minoritized populations, because the court is using the same tool as everyone knows here. The court is using the same tool to restrict the government's ability to enforce non-discrimination laws, right? So you have courts that are saying, this Republican-dominated court that is saying that the First Amendment makes anti-discrimination laws or public accommodation laws unconstitutional because they're restrictions on speech, on artistic expression, on religion, and so forth. The fact that that same kind of analysis is being used here shows you the connection both between that mode of attack, but also the importance of a robust government intervention to protect consumers, as well as to protect the ones that are most burdened by excessive power on the part of everything from businesses to majority religions.
Do you want to weigh in on this, Salomé, or?
Yeah. Excuse me. I suppose really just to say that, I see it's two sides of the same coin, or maybe more of a Scylla Charybdis kind of situation that privacy law has to skate through in its future to kind of dodge. I jokingly say when people try to bring up the amendment, that's the 800-pound gorilla in the room that I think requires, cautious optimism that we will see judges kind of not take these trends in the doctrine to absurd logical conclusions. But also, to tie it back to the earlier conversation about algorithms, I think not taking that doctrine to its absurd logical conclusions is necessary to meet the kind of the moment we find ourselves in the information economy. So, the phrase that comes to my mind is never let a crisis or never let an opportunity go to waste. When I think of the problems that and the opportunities that, this moment around AI affords us as a group of scholars interested in, human dignity continuing to exist in the future of the information economy, I think as the value proposition of data for entities becomes clearer and the risks associated with data extraction become more apparent both as individuals, for creative artists as their work gets expropriated, but also, as Ari has repeatedly mentioned, to form minority communities that oftentimes get swept up in these larger populational efforts and face the brunt of the harms of these value propositions. We increasingly see the need for things like bans on discrimination. We increasingly see the need for far more ancillary non-individual rights that, to our point, don't just grant individuals sort of a counterpower, but really work to create regulatory counterpower to these kinds of impulses. And all of that requires that we don't take the First Amendment to these doctrinal illogical conclusions. So that's not really a First Amendment point, but I really just kind of want to tie together how central that doctrinal practice is preserving our capacity to meet all of the challenges of this moment.
Yeah, I think that the Supreme Court has generally been very cautious about imposing First Amendment restrictions on privacy law. So with the privacy torts last century, the Supreme Court in a number of cases really more nibbled at the margins of the law. Its First Amendment interventions were very measured, very limited, not that extreme, and the privacy torts survived First Amendment scrutiny. And I think Sorrell can be read, which is a case that, even in, like about 10 years ago or so, can be read narrowly as just, involving a more narrow reading. I do think, though, that we are seeing some more aggressive movement out of the Supreme Court and the more aggressive interpretations of the First Amendment as a not really a way to promote what I think is free speech of people, but really a kind of deregulatory tool. And if the court takes that turn, we could really see a different First Amendment regime, and the First Amendment could really become kind of an anti-regulatory type of device. Hopefully it won't go that radically, and the optimism bears out to be true. But it is a concern, because I do see the court kind of making noises that way sometimes. I also think, though, for a little bit of optimism, we have the fact that the U.S. is no longer the only game in town. We have the profound influence of the EU, and global business takes note of the EU. It's a gigantic market. 450 million people, which is more than the United States, 350 million or so. And their law, if you look over the last 20 to 25 years, I think that they haven't gotten closer to the United States, but the United States has gotten closer to them. They've and if you look at what companies do and they comply, it's looking to the GDPR as their blueprint. And I think the AI Act will become a blueprint for a lot of businesses that want to have business in that market. And so the U.S. could either be a leader in regulation, or it could be a footnote and a follower, and basically let the EU regulate and just follow. And so I'm not sure that creating really weak-gutted laws in the U.S. really ultimately is a good long-term position for the U.S. to be in. And I don't think that it means that they will suddenly gain ascendancy in the global conversation. And right now, privacy law is a global conversation with countries around the world, and they're not enacting laws like the U.S. They're mostly enacting laws in the model of the GDPR. So I think that we also have that part of the story. The U.S. might do what it does, and it certainly has some influence. But also, if the U.S. decides to kind of take a back seat, then it's just going to be left out of the conversation. But it doesn't mean that we're going to see worldwide deregulation. So heartened that the U.S. isn't the only voice here. No matter what happens with the First Amendment, there still is going to be regulation of privacy and AI through the EU, and it's just going to mean they'll just lead the way even more, because most business using these technologies is global. Any final thoughts by anyone? Any quick final thoughts about where we are, where we're going?
I'll just agree. I think that, in short, what Ari identifies as the laissez-faire wave in the United States used to be something that looked like a competitive advantage, and now looks like it enables a Brussels effect on steroids. So very much agree with you, Dan. The less the US does in this space, the more somebody else is going to regulate it. Cautious optimism.
Yeah, I'll end with a book recommendation. I did a webinar with Anu Bradford, a law professor at Columbia. She has a new book called Digital Empires, which I think is a wonderful book, which talks about the Brussels effect, which is the effect of EU regulation on the world and how it has exerted influence, and also the United States more market-based approach, and then the Chinese, state control approach. And how all these different approaches are jockeying for essentially, to spread around the world. So we have this kind of global battle for supremacy of the regulatory approach. And the U.S., I think, originally with the market-based approach, was really pushing this out and was leading in that approach, but I think has been overtaken by the EU, which is now really dominating the regulatory landscape. Anyway, her book is fascinating. She has a lot more depth than I was able to summarize here, but I'd recommend it to you if you are interested in that dimension of privacy law and the kind of global sphere of which we're operating in today. Thank you all for joining me. This has been a really interesting conversation, and I'm really glad to have it with you. So thank you, and good afternoon, everyone.